Thanks to Jean. And joining me now to discuss is defense attorney Misty Marris. Misty, good to see you. First, what do you make of the alleged threats that James Crumbley is accused of making from jail?
Yeah, it's very curious who these threats were actually directed to. We know that when somebody is incarcerated, that their calls are monitored. The only calls that are not monitored are those that would be privileged between an attorney and a client, or between a clergyman and Mr. Crumbly. So where these threats were directed, we don't know, but it was severe enough to rescind his privileges and to limit his communications. So that leads me to believe that they were significant, and that's why the jail took that extreme measure.
Let me ask, the jury heard from a detective who interviewed James Crumbley after his son's attack, and he said that Ethan seemed fine the morning of the shooting. And I'm curious if not being aware, being unaware of the danger Ethan posed, can that be part of a defense, an effective part of a defense?
So that's the central issue of the defense. There's two issues that the defense will focus on. One is the foreseeability aspect. That's what the statute requires to prove beyond a reasonable doubt. So it's looking at the time frame before Ethan committed this horrible and terrible act, and looking at what the parents, and in this case James Crumbley, knew or should have known based on Ethan's conduct. So he said Ethan seemed fine, but I think there's something else in there that really triggered my mind when I was listening to the testimony. It's that James drove Ethan to school that morning, and we know Ethan had that gun with him. So I think that's something the jury is going to pay attention to. But there's a reason that this testimony is coming out. It does speak to foreseeability, and that's the entire argument, whether or not they knew Ethan had the propensity to commit such a violent act.
Some of those themes, of course, were present when Ethan's mom went to trial as well. Let me turn to Uvalde, Texas. The families of the victims are furious after an independent investigator found that local police committed no wrongdoing for the 2022 school shooting, despite officers waiting, of course, more than an hour to confront the shooter. Misty, what are your thoughts on the findings?
The findings, I understand why the parents were absolutely livid. The findings went a step further and said that it was actually the parents arriving and being upset and panicking at the site that led to law enforcement being unable to do their job. Can you imagine being the parents of one of these victims and sitting there and hearing that? But let's talk about what the report is. The report is a independent investigative report that was uh, brought by the city, the city executives and city officials for the purposes of litigation. So this is an independent investigator who comes in and does an analysis and creates this report that will at some point be used at trial. There's multiple civil litigations going on. There's multiple, the criminal inquiry is still open. There's no charges yet, but it's still open. So all of that being said, what this report really means is that it could be evidence at a trial. It's not dispositive. And by the way, it's at odds with a 600-page DOJ report, which identified significant problems, including what was called cascading failures by the police department. So what happens in the end is these are two competing pieces of evidence in trial. It's more significant, though, for the purposes of terminations of officers that were involved that day. There's 25 officers. None of them were terminated. This report will likely be used to keep them employed. A lot of issues going on. The report, to me, disturbing, but not as meaningful in a courtroom.
Misty Marris, great to have your insight. Thank you.
Thank you.
All right.